Welcome everyone to the GRadulting workshop series. My name is Debbie McCutsky and I am the coordinator of services and programs for Grad Legal Aid. If you are an international student and looking for an update on immigration policies and laws, you are in the right place. Before we get started, I have a few announcements. You may know that GRadulting workshops are on Tuesdays at 12:30. And if you missed our first 4 workshops on health insurance, life hacks, student loan debt, and Maryland driver's licenses, you can find links to the recordings and presentations on our website. And I will share that in the chat in a few minutes. There is not going to be a workshop next week, so we'll be back in 2 weeks. The topic is, how do I avoid accidental plagiarism? I encourage everyone to attend this workshop because we assist students who get charged by the Office of Student Conduct, and almost 100% of the time, plagiarism is accidental. So it'll be a great workshop. I hope you'll attend. All right, so let's get started with today's workshop. Just a few housekeeping notes. Post your questions in the chat, please. Near the end of the workshop, I will post a link to our 6-second survey. And really, it does only take 6 seconds. So please take 6 seconds to do that. And after the workshop, we will email you the presentation, so you don't have to go crazy taking notes today. Okay, so I see that we have 2 guests from the Office of International Student and Scholar Services. Please say hello, Jody Heckman-Bose, the Associate Director of Student Services, and Gabi Gillespie, the Integration Program Manager. Thank you, Jody and Gabi. You guys are always so helpful to us and to students. We appreciate our partnership with you. And next up is our speaker, who is a strong supporter of legal aid at the University of Maryland. We've known her for a long time, and her name is Patricia Minikon. Patricia is the senior attorney and the founder of Minikon Law, LLC, which is a local immigration law firm. Patricia has represented U.S. employers, U.S. citizens, and foreign-born individuals in all areas of immigration law since she graduated from law school. She got her JD from the University of Maryland School of Law, and since 2017, our office has contracted with Patricia to provide one-on-one consultations with international students who have questions. Now, please understand that this does not replace the work that ISSS is doing. So we always encourage you to first consult with ISSS to see if they can help you address your concern. If they cannot, they will suggest that you schedule an immigration appointment with us. And I will put that information in the chat, so to make it easy for you to follow up with that. So today, Patricia is with us as a volunteer, as she has done for many, many years now. So thank you, Patricia, for sharing your time and talent with us. We're so lucky to have an association with you. So take it away. Please share your update.
Thank you, Debbie. Always a pleasure to present to the University of Maryland body. I wanted to start off just because this is an update type presentation. So I wanted to start off by discussing the parameters of the presentation today. I'm going to be discussing changes currently in effect or going into effect in the future. I will not be discussing proposed changes, which are either currently stopped because of a litigation or lawsuit that has resulted in a court order. And I will not discuss proposed or pending legislation that may, just because it may or may not go into effect due to lawsuits or the comment and period, which allows people to write in support or against the proposed legislation or to recommend changes to the proposed regulation or law or policy. And that results in subsequent revisions. So even if I were to discuss it, I would not be discussing how the actual change would look. I will also limit my discussion to options for getting a green card or a work visa following graduation, but only, I do apologize. I will limit my discussion to options for getting a green card or work visa following graduation and discuss it only in the context of the policy changes. So just so you're aware of that, this is a little different from my usual discussions on options for obtaining a green card or other visa options following graduation. I will discuss changes to common immigration processes that students pursue during their studies or after graduation, again, in the context of the changes. I do a very limited discussion of changes that affect students because most of those types of applications would be handled by the Office of International Student Services, and they will address them. All right, now why, excuse me, why do these policy changes matter? They matter because it will affect the visa options you have available to you after you are no longer a student, which would be work visas and green card applications. It may affect your options while you're still a student if you would be sponsored by a family member and try to adjust your status in the US. It also affects US citizens who, or permanent residents who want to sponsor family members who are abroad. And it may affect you if you travel abroad, but to a country that is affected or for whom travel is restricted after, potential entrance to the US visits that country. It also affects your ability to enter the US if you're a citizen of an affected country. And it touches on your ability to apply for various work and study visas. Also, notably, it affects the ability to apply for some benefits associated with asylum, applications for asylum. Now, again, some of these changes are tied to the coronavirus pandemic, and there's no date certain when it'll end. So it makes it a little challenging to plan, especially if there are several bans for entry from countries tied to the coronavirus or tied to, as long as the pandemic continues. So first we'll look at policies affecting entry into the US. On October 13th, next week, a new process will go into effect. It's called a communicable disease bar on entry to the US. It does affect F, J, and H visa holders. And it will allow the Centers for Disease Control Director to establish a procedure to prevent persons from coming into the US if the countries or places they're coming from are deemed to be to pose a risk to the U.S. public of having travelers from there pass on a communicable disease. F is for students, J could be trainee or a student, and H are visa workers in a specialty occupation. Continuing with the new policies affecting entry, there have been several that affect specific countries. So these are proclamations on the suspension of entry for immigrants as well as non-immigrants who are deemed to pose a risk of transmitting coronavirus. So effective in the year 2020, as of January 31, China was one of those affected countries. February 29th, Iran joined. March, citizens and persons who have traveled to the Schengen area in Europe joined. Canada and Mexico land border entrants were the most recent additions for May 21st. It applies to those who are coming to the US from an affected country. And it applies if you've been in that country within 14 days of entry into the US. So one workaround to this and the way to solve it, if it applies, would be to travel to a non-affected third country. Say, for example, you know, you're coming from the Schengen area, you would travel to a non-affected country and then stay there for 14 days and then come to the US. And people have been able to do that successfully. Now, effective October 1st, there is a national interest waiver exception for certain travelers from the Schengen area, United Kingdom, and Ireland. So most Europeans, you know, would be able to qualify for this. Business travelers, investors, treaty traders, academics, students, and journalists qualify. Students who already have a visa can just come on to the US. They don't need to contact an embassy or consulate. Now, students who are seeking a new student visa would need to check with the local embassy and, you know, see if they're scheduling appointments, because right now the Department of State is only working on appointments in emergency cases of people who meet the exception to come to the US, including healthcare professionals. However, if a prospective F1 or M1 student qualifies for the visa, they'll automatically be considered for the waiver so that they can proceed after issuance of the visa. New policies affecting entry to the US include Travel Ban 3.0, which was put into effect February 5th of this year. As you can see, it's been a very busy year as far as immigration policy is concerned and as far as limiting who can enter. So President Trump issued a proclamation affecting specific nationals. The reason it's called Travel Ban 3.0 is that there were other travel bans, Travel Ban 1, Travel Ban 2, and all of those are still in effect, and now these countries join. However, there are some exceptions. For most of the countries, special immigrants who would immigrate with an immigrant visa or a green card based on their assistance to the US government can still proceed to the US. However, for Sudan and Tanzania, the only people banned are diversity lottery immigrants. So anyone who's won the diversity lottery will be unable to proceed. And the visa year for the diversity lottery begins October 1st. So anyone who won would be unable to proceed, you know, with processing at this time, because there is no end for the travel ban. Now, there is a new policy affecting non-immigrants in the US and their status. The public charge rules went into effect very recently, and they now restrict the ability of a non-immigrant to change their status from one status to another, one non-immigrant status to another, and to extend their stay in their current non-immigrant status if they have applied for, have been approved for, or actually use public benefits. There is a new form, I-539, which is the form used to change one's status or extend that status. And now it asks whether the applicant has received or used public benefits, usually in the areas of cash assistance, non-cash assistance like food stamps or SNAP benefits, federally funded Medicaid, and public housing in its various forms. We also have new policies affecting work visas. And one is the Proclamation in June, which will expire at the end of this year, but can be continued if the Secretary of Homeland Security decides that continuance is warranted. Now, because this proclamation is to suspend the entry of immigrants and non-immigrants who would present a risk to the US labor market during the economic recovery following the COVID-19 outbreak, I'm of the mind to think that it will continue because the outbreak certainly hasn't stopped. And it says economic recovery following the outbreak. So that presumes the outbreak would have to stop, and then we would get into an economic recovery period. And then I guess the determination would be made that it's okay to allow people to come in. There are some exceptions. Current permanent residents can still, travel back and forth. Spouses and children under 21 of US citizens, would still be able to enter, would still be able to obtain an immigrant visa once the Department of State and its various embassies around and consulates around the world resume visa issuance. Those persons would still be able to come. However, children of US citizens and permanent residents who are over 21, who are married, brothers and sisters of US citizens, all those categories of visas are now affected by this ban. Another exception is for investors who invest $1 million into the US economy and obtain a green card based on that. And healthcare professionals, so we're talking doctors, nurses, and other healthcare professionals like physical therapists, etc. The exception also covers children who might be aging out of a visa category if they do not obtain the visa before the end of this proclamation. For example, a child under 21 of a US citizen who falls into the exemption category, who would turn 21, say by December, would then be able to make use of this exception. Now, with the embassies closed, anyone affected would have to try to get an emergency appointment. And the embassies, the Department of State has indicated what they consider to be an emergency. So there is some guidance. There is a waiver possible if you do not fit into one of the categories of those accepted from this proclamation. The standard is national interest of the US. So we don't know exactly what that means, but I think if you can tie your reason for entering into the US to a national interest of the United States, your application for the waiver would be considered. A court has temporarily halted the policy, but only for the groups that sued. So it's not nationwide, and it will affect many people. The groups that sued consist primarily of business organizations and some large employers for whom, this law, who employ a lot of non-immigrants who are working in specialty occupations and possess the bachelor's degree or an equivalent. and the J trainees, exchange visitors, and also L non-immigrants, which is a group of persons who have worked previously for a certain amount of time for a company that's affiliated with a U.S. employer. So it's sort of a transferred employee from one of the entities abroad to a U.S.-based version of the company or subsidiary or parent, et cetera. And you can see why those employers would want to be able to continue to transfer their employees across the globe and into the United States from other countries. But again, like I said, the decision temporarily halts the policy. A, it's temporary, and B, it's only going to benefit the groups that sued. So with the H-1B specialty occupation visa program, there was a new policy change that went into effect last April. So it's not so new, but I thought it was worth mentioning. CAP subject employers must register now in order to be included in the H-1B lottery. Then the employers are notified that their selection has been selected to participate in the lottery, and then those employers can file the application. There's a $10 fee per registration for a CAP subject H-1B visa. And the CAP subject simply means that the H-1B, there's a limited number of H-1B visas every year. And so it's subject to the cap of the number of visas available. The non-CAP subject H-1Bs can continue to be filed by nonprofits, academic institutions, and affiliated entities with those academic institutions. Also, there's been a change to the selection order that allows persons who have advanced degrees to participate in the lottery twice, because USCIS will first select all entries, including those from eligible advanced degree holders, and then will do a second round selection for the 20,000 visas available to advanced degree exempt applicants. So advanced degree holders, US advanced degree holders now get 2 chances. So there are policies affecting the process to obtain permanent resident status. And the most overarching change in policy is the change, there's the introduction of a new public charge ground of inadmissibility. There is an exception for humanitarian-based adjustments, which include persons who are granted asylum and are now applying for a green card 1 year later, persons who are victims of domestic violence, persons who are applying after obtaining T non-immigrant status, T standing for trafficking victims, and persons who have been granted U non-immigrant status, which means that they've been a victim of a crime and they've assisted the police in resolution of the matter. And the law enforcement, it doesn't only have to be the police, it can be the state's attorney's office, any prosecutor's office, and the law enforcement entity has certified that that person was helpful in resolution of the case. And this is regardless of whether the law enforcement entity decides to proceed, to trial or is able to get a conviction. So those categories of persons do not have to meet the new public charge requirement. During the adjustment of status process, there's now a new form that applicants have to complete. It's called a Declaration of Self-Sufficiency. It was stopped earlier this summer. It's now effective September 11th. So any applications filed need to include the new form 944. any applications for adjustment of status, that is. This is new in so many ways, but one of the ways it will affect people is that even if you have not received public benefits, USCIS will be looking at your history, whether you have, they want a credit report to assess whether you have bad credit. They want to see your credit score. They want to see if you've ever filed for bankruptcy, and you have to explain why your credit is bad, why you owe, why you've defaulted, why you filed for bankruptcy, because, and that counts as a negative, because as far as USCIS is concerned, you need to be self-sufficient, you need to be able to pay your bills. It is no longer sufficient that you have an affidavit of support that the petitioner filing for you, makes enough money and would be able to support you. Now you have to stand, or the applicant, the non-citizen, has to stand on his or her own merit. If the person has filed taxes, USCIS now wants their tax transcripts. They want a list of all their debts, proof that they have education or skills and can find, I guess, a job that would hire them. The economic downturn in light of the pandemic, the effect of the economic downturn in light of the pandemic remains to be seen, because people may not be able to find a job. And it's uncertain how that will be taken, the fact that they're unemployed, even though they have an education. Applicants for a green card now must show that they either have health insurance or will be immediately eligible for health insurance upon being granted permanent resident status. It used to be, prior to this change, that if someone had lived and worked in the US and had earned 40 Social Security quarters, or the equivalent of 10 years work credits with Social Security, they could just request an exemption saying that the affidavit of support and requirement didn't apply to them. Now, applicants are no longer able to do that. They have to complete the public charge, the new public charge form, which is the I-944. So that means that someone who has supported themselves for the last 10 years would not just be admitted because they've shown that they can, support themselves. They would need to show that their credit is good, etc. And what also remains to be seen is that with the economic downturn and people losing jobs, whether any bad credit or defaults or lateness that would reduce their credit scores would affect them. The suggestion is to just explain how the pandemic, either caused the person to lose their job, etc. So, but it's too early to determine what effect, if any, the pandemic will cause on this process, because this requirement just went into effect on September 11th. So, and interviews on applications for a green card are taking about a year. So, so the programs at issue we covered before under the change of status, and they're repeated here. Usually cash assistance, non-cash that could be used to purchase food, and then federally funded Medicaid, as well as public housing. There is no need to report on the application any application for any approval of a receipt or of SNAP, the food stamp benefits, most form of Medicaid and public housing, before that was used before February 24th of this year. And any use of such benefits before February 24th of this year will not be weighted heavily as a negative factor in USCIS's determination of whether the person is not admissible to the US and therefore not qualified for the green card. Programs that are not considered public benefits and would not disqualify a person or make them inadmissible for obtaining the green card includes unemployment benefits, workers' compensation benefits, state and federal disability benefits, tax credits, Affordable Care Act health insurance if you are qualified to obtain it, because that is tied to immigration status, and any benefits used under the Women, Infant, and Children programs. Usually these benefits are for pregnant women and infant children. Like I alluded to earlier, there are new policies affecting asylum applicants, and some of the changes which went into effect on the 25th of August, but has been stopped for members of two organizations that sued. The first is CASA of Maryland, and the other is Asylum Seeker Advocacy Project. So on September 11th, the court ruled that the law would not apply to members of these organizations. So if you find yourself in any of these categories, you are free to join CASA of Maryland. Their membership fee is fairly reasonable, and then you would qualify for, the new laws would not affect you, is what I meant to say. So starting August 25th, persons who apply for asylum need to wait for 365 days before they can apply for employment authorization. It used to be they had to wait 150 days. Now, what happens now when someone applies for asylum, which is basically seeking protection from the US government due to harm on 5 bases: race, religion, particular social group, political opinion, or your nationality, and you fear harm by your government or the groups or entities your government cannot control, and your government is unwilling or unable to protect you from those groups. When you were interviewed in the past, if the asylum officer had not completed your fingerprint checks, run the background check, they would recommend an approval and would give you paperwork to that effect. That is being eliminated. Anyone who enters the United States illegally would be denied work authorization after they apply, because applicants for asylum used to be eligible to apply for work authorization while the application was pending. Right now, it takes 4 to 5 years to get an interview. So for someone who enters the US without a visa, they would not be able to work until they were interviewed 5 years later. Someone who does not file for asylum within 365 days of entry, as is required, would also be unable to get work authorization. The law does require people to file within 365 days of entry. However, if you can prove, that you fall within some exceptions, then it wouldn't apply to you. It's uncertain how those situations would work out with the work authorization denial. When a person applies for asylum, if they're not granted, they can appeal it to the Federal Court of Appeals after they've exhausted the immigration system appellate scheme. These persons will no longer be able to get a work permit during their Federal Court Appeals, even though their application is technically still pending. So when someone applies for asylum, if they cause a delay in any part of the process, it in turn affects their waiting period. So if you cause a 1-month delay, your waiting period is extended by a month. So they've increased the reasons for the delays, which now includes needing to edit, needing to file a supplemental application, which happens frequently when people represent themselves and then hire an attorney who realizes that the application needs to be stronger. But in these cases, this would cause a delay, and the person would have to wait for as long as it takes. Basically, if person A files January 1st and they hire an attorney October 1st, the attorney files, their the 365 days starts from October 1st. So this will cause a lot of problems. Now, asylum applications before now were free. The application was free. You did not have to pay a biometrics fee. However, as of August 25th, applicants are now required to pay a biometrics fee, which stands at $85 right now. So, like I said, these are major changes. Effective June 22nd, USCIS is no longer required to process asylum-based work authorizations within 30 days. So, and applicants will no longer be required to apply at least 90 days before their current permit expires. Work permit renewals, though, for some time now, at least for the last year and a half, have been automatically extended for 180 days if the person applies while their current work authorization is still valid. There was one glimmer of hope in the last year or so, and that was the passage of the Liberian Refugee Immigration Fairness Act, which allows nationals and non-nationals of Liberia, if they have the requisite relationship, to obtain a green card. They do not need sponsorship. It was passed December 21. The deadline to apply is December 20th. There is a requirement that the applicant must have been a resident in the US on or before November 20th of 2014. The applicant has to prove citizenship and prove continuous physical presence in the US since November 20th of 2014. Spouses and unmarried children are eligible even if they were not in the US on or before November 20th of 2014. And a non-Liberian spouse who is not a permanent resident and unmarried children who are not permanent residents are also eligible. So it's fairly generous. However, certain criminal convictions will bar eligibility for this. And the deadline to apply is the 20th of December of this year, which may or may not cause some problems for people just because sometimes getting the proof of continuous physical presence takes a while to gather. The application fee is $1,225, and some people may or may not have it. But those are basically the new policies. Generally, it's been a very busy year with immigration as far as who can and cannot enter the US in immigrant or non-immigrant status. And so most of the emphasis has been on that. There are also proposals that will change the immigration landscape if they go into effect. But as of yet, they're not in effect. So at this point, I'll stop speaking to allow people to ask questions. Do we have any questions, Debbie?
Not yet.
Oh, okay, all right. Okay, well,
Well, while we're waiting, I want to see
Yeah.
if Jody or Gabi has anything to share with the international students that are with us today. Any announcements or anything we should be thinking about or preparing for?
Sure. We are still waiting for any announcement from Department of Homeland Security regarding what flexibilities they will allow for the spring semester for F1 and J1 students. As our F1 and J1 students should know, they've allowed quite a few flexibilities for the fall semester. Students can be fully online. However, we haven't received any updates yet as to what will be allowed for spring. Because of that, we are recommending caution for students traveling over winter break until you learn and we learn about what will be allowed for the spring. And we don't know when to expect that. If we look at when it was announced for fall, we got an announcement on August 1st with the flexibilities for fall. So that did not give us a lot of time. And given that this is an election season, I really don't expect anything earlier than what we saw for the fall. So that is, that's difficult for our community. The other piece, Patricia did mention, she's not discussing it, but I do want to remind students that the information that our office sent out to F1 and J1 students regarding the D/S is simply a proposal. This was a proposal that was sent forth. It is not enacted yet. They are taking comments regarding these changes, but they are significant changes. So we encourage you to read that email that we sent. We have it on our website, what the proposal is, and we are inviting comments directly to our office so that we're aware of what the concerns are to you as an F1 and J1 student. You can also make direct comments to the government's webpage regarding how you feel about that proposal.
And did you have anything to add, Gabby? Because I wanted to just comment a little bit on the changes that were just mentioned about the DNS and the ability to comment directly. That's one of the, for a lot of international students, there are various countries may or may not have this open comment period where the government just takes feedback from anyone who is an interested party or wants to comment. And it's something that I think that anyone affected should definitely take advantage of to do that and share it with ISSS, just because a lot of times organizations respond in their official capacity or as part of a larger, say academic group. And it's good to know from the people who will be experiencing this. And I haven't seen whatever the memo ISSS sent around, but the change, it's really that before, if someone were on a student visa and they had the designation DS on their I-94 or stamped in their passport, they were deemed to still be in status and not accruing unlawful presence, even though they may have graduated and just never left, until there was a formal decision by USCIS or say an immigration judge saying that their status as a student was now terminated, or any other types of visas that carry that DS, duration of status notation. However, with these changes, that would no longer be the case. As soon as the person, say, graduates, they would lose that protection and start accruing unlawful presence. And unlawful presence has a huge impact on your ability to obtain a green card if you travel, on your ability to come back. Because if you accrue 180 days of unlawful presence, unless you're being sponsored by an employer and you meet certain exceptions, you will have to leave the US for 3 years before you can obtain that green card, be it by a family member or by your employer. And if you accrue 365 days of unlawful presence, you have to stay out for 10 years. There are waivers, but it's limited to extreme hardship to a spouse or a parent. And a lot of, the hardship has to be a situation that would take it outside of that normally experienced by a family member who a family member who would lose or be separated from another due to removal from the U.S. or failure to maintain status. So the bar is pretty high. Usually it has to involve some sort of illness or mental condition or something that would require the presence of that relative. So this is where, you know, obviously the spouses of U.S. citizens will continue to be exempt from it, just because spouses of U.S. citizens or immediate relatives, spouses of U.S. citizens, parents of U.S. citizens, children under 21 of U.S. citizens would continue to be able to adjust their status regardless of whether they've fallen out of status, as long as they have entered the U.S. with a visa. So there's, you know, if that proposal goes into effect, yeah, it will cause some chaos. Another pending change is an increase in application fees for USCIS, but that again has been stopped by court order. We're not sure if it'll ever go into effect or not, but it's something to keep in mind because they literally like doubled or more than doubled, say, the citizenship application fees and impose additional fees. Some applications had higher fee increases and some did not. It's proposed if it, you know, so it gives you an idea of where they're going if it happens. USCIS claims they don't have enough money. They don't get enough money from the fees because their budget is, you know, basically they raised their budget from application fees, and they're going to furlough, you know, like tens of thousands of workers. That obviously, if it happens, Congress got involved and had a hearing once they heard that. But if that happens, you know, with this fee rule being stopped by the courts, recently, USCIS responded by saying, well, they already don't have money and they're stopping, you know, one means of them raising their budgets. So if USCIS furloughs that number of employees, I believe the amount was like 13,000 or something. If that happens, it will cause a huge slowdown in applications, which will affect everyone concerned with pending applications, reinstatements to student status, change of statuses, applications by employers, et cetera, et cetera. So that's just something to keep in mind. But again, it's not in effect right now. So one thing I will say about practicing immigration law in the last year is that things change. We literally from, you know, week to week, we have changes because of the various lawsuits. 1 minute there's a temporary restraining order, the next something's going forward, or it's going forward and then there's a restraining order. So yeah. Do we have any so far? No.
Any more questions?
Yeah.
You've done such a good job of predicting what everybody wanted to know, Patricia.
It seems like it.
Well, if anyone has a lingering question, please, you can contact ISSS first and see if they can help you. You can also schedule a consultation with Patricia. I'll be sending out an email this afternoon with her presentation, as well as links to past workshops, future workshops, and how to schedule an immigration appointment. So if there are no more questions, I will simply thank Patricia for, gosh, helping us roll with the changes. I don't envy you being in this business, but we really appreciate you sharing your time and your talent with us. And thank you also to Gabi and Jody for jumping in, answering questions, helping out with the chat, and just for helping our international students. It's been a rough year and we need to stick together and be informed and just roll with it. So it was good to see everybody. Hopefully we'll see you in 2 weeks at the plagiarism workshop. In the meantime, stay safe.
Okay, thank you, Debbie. Always a pleasure. Okay, bye.
Bye-bye.